Thank you, Deputy President, and I rise tonight to speak in favour of this legislation. I first want to thank the Attorney-General and our government, the Minns Labor government, for bringing about this important reform. And I particularly want to commend the swiftness of the Attorney-General and his office in acting on this gravely important issue. I also acknowledge the presence today in the chamber of Latoya Aroha Rule and Alison Whittaker from the Ban Spithoods Coalition. I thank them for their advocacy on this issue and hope that this bill in New South Wales will serve as a model for other jurisdictions around Australia to follow so that we can end the use of these dangerous and despicable devices. This bill defines a spithood as a, quote, covering, however described, intended to be placed over a person's head to prevent the person from spitting on or biting another person, end quote. Generally, a spithood is a hood that covers the face or mouth of the wearer. It can usually be secured at the base, around the wearer's neck, and it can be made from various materials, including mesh. Spithoods present a risk of choking and asphyxiation and can cause trauma, injury, or even death to the wearer. These risks make the use of spithoods inexcusable, especially when the alternatives are considered. In New South Wales, law enforcement and health workers use alternative methods of protection against spitting, such as personal protective equipment and the use of de-escalation tactics. A worker who is spat on in New South Wales may also be able to apply for a mandatory disease testing order under the Mandatory Disease Testing Act of 2021. Furthermore, spithoods are an obviously dangerous method of restraint that do not solve any of the underlying problems that cause incidences of spitting or violence in custodial settings in the first place. In the words of my father, Justice Murphy, in his seminal judgment in Neil and the Queen, 1982 HCA 55, at paragraph 20, he said, I quote, "Spitting is humiliating and degrading. It is a typical response of children and others without power, attempting to humiliate and degrade those who are seen as oppressors. The sentence of imprisonment imposed upon Mr Neil will not improve race relations, but will tend to embitter them," end quote. Spithoods serve only to introduce a further level of escalation to the situation, and they don't address the inherent power imbalance between figures of authority and detained persons in those environments. There are better, less dangerous, less violent ways to reduce cases of spitting, as well as the methods already used to mitigate its effects. The fact of the matter is that spithoods are a dangerous form of restraint and one that has no place in a compassionate and civilised society in which the human rights of all people are respected, even those who are incarcerated or detained. Many have called for a ban on spithoods in Australia, including Amnesty International and the United Nations Subcommittee on the Prevention of Torture, the 2017 Royal Commission into the Protection and Detention of Children in the Northern Territory, and a 2019 investigation by the South Australian Ombudsman into the use of spithoods at Adelaide Youth Training Centre also recommended that their use should be prohibited. The idea that these devices have been used on children in these settings is chilling. It brings to mind the startling images of a young boy, Dylan Voller, restrained and hooded at Dondale Youth Detention Centre. Images that captivated the nation and led to the aforementioned Royal Commission. These are atrocities that should never be repeated. South Australia was the first jurisdiction in Australia to criminalise the use of spithoods in 2021, following the death of Wayne Fella Morrison. A 29-year-old Wiradjuri Kakartha and Marangu Man in 2016. Again, I note the presence of Latoya Rule, Mr Morrison's sibling, in the chamber tonight. Credit for this monumental change must be given to their family and their supporters, and I again thank them for their advocacy. Still, it shouldn't take a death to achieve change. I'm very proud that New South Wales is leading the charge for other states across the country to outlaw this practice. Unfortunately, the use of spit hoods continues in other jurisdictions, such as Queensland. In October of last year, an inquiry was undertaken in Townsville into the death of Salisa Tafaifa, a Samoan woman who died in custody. Video footage of that incident has revealed that Ms Tafaifa, who had asthma and other health concerns, was forcefully restrained by officers and had a spit hood placed on her while in respiratory distress. 6 minutes after the confrontation began, she was dead. Ms Tafaifa repeatedly stated, I quote, "I can't breathe," end quote. That statement now has a new resonance following the tragic death of George Floyd at the hands of police officers in the United States in 2020. On the 22nd of November last year, I spoke in this place about the death of Ms Tafaifa and the continuing tragedy of deaths, particularly Aboriginal deaths in custody. Then I called for a nationwide ban of spit hoods. I continue that call today and hope there is a day soon when the use of spit hoods is prohibited by law across Australia. This legislation is important not only because it makes clear that there is no doubt on this matter, spit hoods are unlawful and should not be used in New South Wales, but also because it serves as an example to other jurisdictions that still use spit hoods and where they should be banned. Following the consideration of this matter by the Standing Council of Attorneys General last year, I'm very hopeful that the use of spit hoods can be eliminated, not only in New South Wales, but across Australia. Again, I thank the Attorney General for bringing this bill and I commend it to the House.